More specifically, I will argue that Article 2b of the 1948 Genocide Convention, meaning the act causing serious bodily or mental harm to members of the group, could provide, once qualified, for further guidance and also serve as an early warning sign that genocide is about to occur. This is due to the International Criminal Tribunal's interpretation and understanding of the act, which also covers a series of non-fatal acts. In practice, this means that Article 2b and those acts accordingly qualified as such, if committed with the intent to destroy, can be called genocide without the physical destruction of the group. Before I delve into the legal discussion, however, I would like to start with the following quote. "I was born in a part of the world in which various nationalities lived together. They disliked each other and even fought each other, but in spite of the turmoil, they had a deep love for their towns, hills, and rivers. It was a place of 1,000 miracles to be discovered every day. A place of 1,000 miracles to be discovered every day, and a deep love for their towns, hills, and rivers." This provides for an accurate summary of how I felt when I visited Bosnia and Herzegovina for the first time. I returned in May a year ago to spend some more time here for research purposes, and I was in Sarajevo, Tuzla, and Srebrenica to be able to gain a better understanding of a history and a culture of a country that I predominantly knew from textbooks and judgments. From my first day, I was welcomed with inexplicable kindness and a kind of warmth that I hadn't experienced in this way before, so I would like to take this opportunity to also say thank you. The aforementioned quote, however, does not refer to Bosnia and Herzegovina, but instead relates to Poland and stems from the lawyer Raphael Lemkin. He said this in the aftermath of the Second World War. He himself was a survivor of genocide and a very courageous man who coined the term, but he also dedicated his life to the adoption of the 1948 Genocide Convention. His way of remembering the horrors and honoring the victims of the Holocaust was not only to hold those responsible, but also to prevent further crimes of similar character. In July 1995, Lemkin's legal attempt to prevent was disregarded when, quote, "The world witnessed a historically resonant separation of women, children, and elderly from the men. It was as if the international community expected someone who was going to commit an act of genocide to say, 'I'm going to commit an act of genocide.'" My research visit to Bosnia-Herzegovina last year was connected to my research at the time, which investigated the responsibility of the Netherlands for the failure to prevent the genocide in Srebrenica in relation to their troops on the ground at Potocari under the umbrella of the United Nations peacekeeping forces. During my trip, I was fortunate enough to interview Hasanuhanovic, a doctor who works next to her own practice in Tuzla for an organization called Snagaščene, supporting women and families that have been victims of war-related sexual violence, and also a young man. He's a Bosniak. He's around my age, and he hopes to sort of revive the town of Srebrenica with his rock music. All of them had one thing in common: their continuous struggle for justice, recognition for past events, as well as compassion for humanity. The international community looked away at a moment in which it was absolutely inexplicable to do so. The Netherlands at the forefront, but every other state who knew or could have known about the events and had means available to counter the commission of genocide had the obligation to do so according to the Genocide Convention. I chose this quote by Samantha Powers because I really pledge for us to start fighting for a world in which political will and national interests have absolutely no place in the context of mass atrocity prevention. The 1948 Genocide Convention calls for the prevention of the crime on two occasions. Firstly, in its title, you can see it bold marked on the PowerPoint, and second, in Article 1, which reads, the contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and to punish. Accordingly, my research questions today are the following two. One, what is the scope of the international obligation for states to prevent genocide? And two, where can we find legal guidance on genocide prevention? Firstly, I'm going to be looking at the genocide case decided by the International Court of Justice in 2007. And the court firstly pointed out that the obligation to prevent genocide is an independent obligation-creating provision. And secondly, the obligation to prevent genocide is not one of conduct and not one of result. And this is a very important statement which is further defined in the following paragraph. Quote, the obligation to prevent the commission of the crime of genocide is imposed by the Genocide Convention on any state party which in any given situation has in its power to contribute to restraining in any degree the commission of genocide. The obligation to prevent genocide places the state under a duty to act which is not dependent on the certainty that the action to be taken will succeed in preventing the commission of acts of genocide or even the likelihood of that outcome. Moreover, the moment was defined by the court in which the obligation to prevent genocide commences, namely, it begins the moment that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to its means, likely to have deterrent effect on those suspected of preparing genocide or reasonably suspected of harboring specific intent, it is under a duty to make such use of these means as the circumstances permit. Now we have an idea of what the obligation for states to prevent genocide is under international law. I would like to move on to Article 2b and examine whether this act can be used as an effective tool for prevention. Israel Chani rightly points out the imbalance between the two limbs of the crime of genocide and also within the field of genocide studies. He says, our developing field of genocide studies needs to emphasize efforts at prevention much more. Even if these turn out to be our failing end-of-species efforts, for me, the effort to stop genocide is what gives greatest meaning to being alive while we are. Just as a little reminder, the act I'm talking about is Article 2b, and it means committing genocide by means of causing serious bodily or mental harm to members of the group. In order for an act to qualify as genocide under paragraph B, two thresholds need to be reached. We have one of intent and one of seriousness. The intent requirement is fulfilled when an act is committed against one or several individuals because such individual or individuals were a member of a specific group, and specifically because they belong to this very group. The seriousness threshold is fulfilled when bodily harm or mental harm is inflicted on members of a group and they are of such serious nature as to threaten its destruction in whole or in part. The international criminal tribunals interpreted and defined paragraph B, while also giving a few examples. The ICTR defines serious bodily and mental harm as to be an injury that does not need to be permanent, and it mentioned as an example serious acts of physical violence, including sexual violence, falling short of killing. The ICTY stated that this harm must involve harm that goes beyond temporary unhappiness, embarrassment, or humiliation. Emphasis added, it must be harm that results in a grave and long-term disadvantage to a person's ability to lead a normal and constructive life. In subscribing to the above case law, the Chamber holds that inhuman treatment, torture, rape, sexual abuse, and deportation are among the acts which may cause serious bodily and mental injury. The ICTR further determined that quintessential examples of serious bodily harm include torture, rape, and non-fatal physical violence that causes disfigurement or serious injury to the external or internal organs. So here we have the proof that death is not required in order for an act to qualify as genocide under paragraph B, given the intent requirement is fulfilled and the threshold of seriousness is fulfilled as well. The most recent example I could think of, an example of serious mental harm, which was upheld by the appeals chamber in Ptolemy, and this is very recent, on 8th of April 2015 this year, where it was found that serious mental harm happened to the women, children, and elderly that were forcibly deported from Potocari. And it was argued by the appeals chamber that they were victims of serious mental harm because what happened to them, the forcible deportation, resulted in a grave and long-term disadvantage to them to lead a normal and constructive life. And this was caused by the uncertainty they faced with regards to their husbands, their brothers, and their fathers, due to the economic and emotional difficulties they faced after the disappearance. And I would like to read out one quote by a witness that was also highlighted by the court and also restated by the appeals chamber. And the woman said, "I live, but actually my life does not exist." Or we can say, "My life goes on, but I do not exist." In conclusion, the jurisprudence and interpretation of the International Criminal Tribunals expanded the scope of application of paragraph B and indeed added a preventive dimension to the act. And this preventive dimension exists in the potential that Article 2B, committed with the intent to destroy, can constitute genocide and be recognized as such before the protected group has been destroyed in its entirety and in physical form. Professor Leitsdorf, however, warns of the limits of the law as a tool for prevention, accountability, and reconciliation. She states, when we subordinate the victims to newly manufactured legal accounts and thereby phase out everything else, we shall finally put at risk our ability to understand history. At the end of my presentation, I would like to summarize that the discipline of law is not the tool to ensure a long-lasting memory, not standing by its own. I strongly believe that collective memory results from an interaction of narratives that eventually reconcile into one, and in the course of the last 2 days, we addressed a couple of them. However, there is an international framework in place on, albeit its faults and its flaws, it demands and offers to us guidelines on prevention and punishment of the crime of genocide. However, this effectiveness of the implementation and application of those international obligations largely depend on political willingness and judicial expertise, and this is something that needs to be changed. Prevention is so vital in the context of discussing a long-lasting memory as we are here today, because the wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. Because we remember, we have to prevent, and because we prevent, we have to remember. Thank you very much for your attention.